Kat writes in with a question about using titles and snippets of dialogue from famous movies in her new script. Stick around for my response. Hi, I'm entertainment lawyer Gordon Firemark, and this is Asked and Answered, where I answer common entertainment law questions to help industry professionals like you realize your dreams. So here's Kat's question. My co-author and I have just written a spec script in which the titles of 4 famous Hollywood movies are mentioned. 2 of them are genuine 1960s classics. The films are an integral part of my strip's plot. They inspire the protagonist's action. Moreover, a brief bit of dialogue of one of these movies is quoted, and part of a scene from another one is inserted in the script. The question is this: is it realistic to think that the production companies interested could obtain authorization to use this material, and in that case, would the cost be affordable or ultimately impracticable? Well, first off, just referring to the title of the film, or the brand name of a product for that matter, is what trademark lawyers call a nominative use, and it's perfectly allowable. Trademark and unfair competition laws are designed to prevent consumer confusion, and the mere mention of something in the dialogue of a movie is not likely to create that confusion. So it's probably okay as long as you're not creating some false suggestion that there's an endorsement or affiliation between the old film and the new. As for the dialogue snippet, it really depends on a number of factors. A recent case involved the Woody Allen film Midnight in Paris, in which Owen Wilson's character quotes, or actually misquotes, a line from a Faulkner novel. The Faulkner estate sued, and the court ruled that it didn't amount to copyright infringement. But ultimately, each situation will be different, and the outcome depends on exactly what's taken, how it's used, and the market for the original. The answer is pretty much the same for the clip from one of the films, but in order to use that clip, there's a raft of other legal hurdles to be overcome. First, the owner of the film will have to be consulted, but also each actor in the original film will have to have signed a release that authorizes the relicensing of the clip. And I should note that this is not always the case when actor contracts are done. So you'd have to go and get the actor's consent and that of their union, the Screen Actors Guild. Then, if there's any music in the clip, the composer and maybe the recording artist might also have to give consent. Script clearance is a big part of what film production lawyers do. It's somewhat complicated, but not impossible. The real question is whether it's too much hassle or too costly, and thereby makes your script a hot potato that producers won't want to deal with. The bottom line is this: if the script is great, but it involves some technical or legal hurdles, well, that will always be a factor, but you as a writer shouldn't let it deter you from including the elements that make your piece a great one. Be mindful of cost, of course, and the complexity, sure, but don't let them interfere with the storytelling. If you've got a great script, the producer will do what it takes to get it made. Besides, scripts change repeatedly before the film is finished. Who's to say that the scene you described will even make it into the final cut of the picture? So I say go for it. Hey, do me a favor, subscribe to my YouTube channel. It's easy, just click the button. And if you'd like to submit your question, go over to firemark.com/questions, or click right up here.